All parties involved in the matter of Olivia K. Johnson v. Jasmine D. Dukes, please enter the courtroom. The Honorable Judge Marisa Starr of Star TV presiding. All parties directly involved, please raise your right hand. Do you all swear to tell the truth, nothing but the truth, so help you God? Ma'am, excuse me, ma'am, mulatto, you look like you lie. Raise your hand again. We're going to have you do it twice. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Yeah, I'll tell the truth. You tell the truth. I don't lie. I tell the truth. Okay, ma'am, you may be seated. Order in the court. Order in the court. So today we are here in a case of, is that harassment? Olivia K. Johnson, Jasmine D. Dukes. And at first, we're going to start with a word from the defense attorney.
Harassment, at first glance, it looks like it's not a big deal. I mean, what is this? I haven't really hurt anyone. I'm harassing them. What does that mean? I'm annoying them. And there is some truth to that element, but understand it's an arrestable offense, which means you could have a criminal record. You could end up with a conviction, which could make it difficult for you to find a good job. And here's the other thing. Many employers see a harassment charge and conviction as as a sign that maybe someone's unstable. Maybe someone has some mental health issues. You don't want to be labeled with that. So it's important that you fight your harassment charge so that you get the very best result that you can possibly under the law. Now, what qualifies as a harassment charge in Texas? Usually it arises when an alleged victim receives some form of communication from the accused. For example, maybe an in-person visit, maybe an email, maybe some text messages or phone calls. And that, as a result of that contact, it, quote, annoys or alarms them to the point of calling the police. Now, the biggest challenge for the police will involve proving that you were the person, number one, that made that communication and that you actually acted with criminal intent. We're going to get into those defenses here in just a minute. For example, there are times when criminal intent can be inferred based just upon what happened. For instance, we've seen cases where someone literally called someone 500 times in 24 hours, and they called and left multiple messages over and over again. In that situation, you may be able to infer criminal intent much easier. Or maybe a particular phone call or a voicemail was left where there was a specific verbal threat that was made, well, maybe a threat of bodily injury against that person or a family member. In that situation, it's a lot easier for the state to be able to prove criminal intent. But some of the more common examples of how people are charged with the charge of criminal harassment is, let me give you some examples. Maybe communication with someone with the intent to annoy them, describing certain things, or saying you need to do this or you need to do that. And those sort of things repeatedly over and over and over again makes it more objectively likely that a jury would believe that they were done with the intent to annoy or alarm. Now let's look at Texas Penal Code section 42.07. It says that the state of Texas must prove the following elements of harassment beyond a reasonable doubt. Here's what it says. A person commits an offense of harassment if, with intent to harass, annoy, alarm, abuse, torment, or embarrass another, he initiates communication by telephone, in writing, or by electronic communication, and in the course of that communication makes a comment, request, suggestion, or proposal that is obscene. We'll talk about what obscene means here in a minute, okay? Number two, threatens by telephone, in writing, or by electronic communication in a manner reasonably likely to alarm the person receiving the threat, to inflict bodily injury on the person or commit a felony against the person, a member of his family or household, or his property. So the first is obscene communication. The second one is threatening communication, literally making a threat against that person or a family member of that person. Number three, conveys in a manner reasonably likely to alarm the person receiving the report, a false report, which is known by the conveyor to be false, that another person has suffered death or serious bodily injury. Good example of that is if someone calls and says, this family member of yours has died, lying about it, putting that person to alarm them in order to scare them, that would be that example number three. Then we go to number four, causes the telephone of another to ring repeatedly or makes repeated telephone communications anonymously or in a manner reasonably likely to harass, annoy, alarm, abuse, torment, embarrass, or offend another. All right. That's just calling somebody like crazy. That's basically what that's saying. And then the next one is to make a telephone call and intentionally fails to hang up or disengage the communication. You see what we're talking about here? All right. And then the last one under the law, knowingly permits a telephone under the person's control to be used by another to commit an offense under this section, or sends repeated electronic communications in a manner reasonably likely to harass or annoy or alarm another. All right. Now, here, let's talk about it. I told you what that definition of obscene would mean. That's under Texas Penal Code section 42.07B3, says obscene means containing a patently offensive description of or a solicitation to commit an ultimate sex act. And you know what that is. Basically, at some type of obscene messages that are sent. Okay. So let's talk about this for a second. The more common example, I would say probably 90% of the time, someone is charged with harassment is where it's related to electronic communications or telephone calls that are repeated in nature. Okay. Now let's talk about this. Can electronic communications be considered harassment in Texas? Now, look, everyone has a smartphone now. Everyone sends messages. Everyone sends emails back and forth. So the most common example of electronic communications that have been used to establish harassment claims have been what? Social media posts. They've been messaging through apps or text messages. And until recently, sending an alleged victim repeated messages through an electronic communication would have been seen as probable cause for an arrest and could be moved forward as a harassment charge. However, it must still, even in the past, old law, it must still have been shown that they were sent with the criminal intent to annoy or alarm the alleged victim. However,
attorney, are you saying that intent determines whether somebody can be found guilty of a harassment charge?
Right now, remember I told you at the beginning of this video, the state of harassment law is a little in flux. Well, that's because the Texas Court of Criminal Appeals, their decisions have somewhat limited the use of electronic communications as a basis for harassment and some stalking charges as well, because those are closely related to each other, okay? And so why? Well, the courts have ruled that many electronic communications are essentially First Amendment protected. It's free speech based, okay? And think of it this way. If someone keeps sending you text messages, what can you do? You can block them, right? You can also block.
Oh, so you mean in forms of electronic communication that the person that is considering themselves harassed or threatened has the capability to filter or fail to expose themselves to said communication. So, okay.
Block their email. So many of the courts have said, nah, not real sure about that. Right now, we're going to say that that's not valid. That's critical for you. There are many detectives who do not know this. They are still not up to date on Texas law and the changes that have been made through the recent Texas Court of Criminal Appeals rulings. Okay. Now, how does Texas harassment law define threatening communication? Because we talked about what threatening, there is an element of threatening communication for one of the examples. First, it's critical to remember that the state must always prove beyond a reasonable doubt that the communication was threatening, all right? And it must be so objectively. So in order for them to meet their burden, they would have to look at the context of the messages to determine if they are overtly threatening or not. So a message that is, and here's what your lawyer needs to be looking into. Let's say the message is vague. Let's say it's ambiguous. Let's say that sort of situation where it may not have been directed at a particular person. That can pose a problem with the prosecutor for them being able to prove their case. Most threats, in order to be proven in a jury trial, will need to be specific to the alleged victim and specific enough to make it clear that the intent was credible as to time and place as to what was going on. That's
So, Mr. Defense Attorney, on behalf of Jasmine D. Dukes, it sounds as if we may have a case of not being clear on intent. So, Olivia K. Johnson, being that you're here defending yourself because we know you didn't pay for a lawyer, did you have any reason to believe that Jasmine D. Dukes would indeed make good on those threats? Ms. Johnson, no. I said, please listen to the question, ma'am. Did you have any reason to believe that Ms. Dukes would make good, or did you notice an effort of Ms. Dukes to make good on those alleged threats? And what evidence do you have to prove that she made good? Has she made contact with you in person, you all? are in the same state, about a few hours away from each other. So that's a reasonable distance to travel, you know, in order to inflict harm on somebody. So what evidence do you have that she intended to make good on these threats? None. Okay. So going back, how did this all start? Olivia K.
Talking about, but listen to this.
The thing I don't like, and let's segue into the next topic. The thing I don't like is bitches who throw rocks and hide their hands. You know, the scary ass bitches in the back. You know, the bitches who try to act like me because they don't have no identity. Them bitches, yeah, shut up. Anyway, let me be nice. I don't want to make a bitch cry today. But I'm telling you right now, and I'm going to try not to cuss. Females are treading, however you say it, a thin line.
Okay, thank you, Witness Destiny Reacts. We appreciate your testimony in that manner. It sounds like that is where the dispute began. And then let's find out, how did it progress from there? Ms. Dukes, we will now Ms. Dukes, are you saying all this began around or on about May the 10th of 2024 when you got online and I guess exposed the fact that Zolo was the child's father to Olivia K. Johnson, and I do believe that the K stands for Karen? Okay. So this is where the incident spiraled out of control, it sounds like. So, what happened next in the chronological order? We're going to go in order. Ms. Johnson, sit down, Ms. Johnson. I will have order in this court. Ms. Johnson, I will have order in this court. Now you sit down and be quiet and tell your mother to move to the back row. Thank you. Now, on to the next stage of evidence.
Issues that I want to address on this live. And we're going to start driving in a minute because I have to meet the CPS worker at my house so he can take pictures of the babies, which it's fine. I do care because it's like, that's fine. He can come and he can see the kids and he can take pictures of the kids. But the deflection is at like an all-time high at this moment. Let me say this. I didn't want to get involved in anybody's situation, but when my kids' names were spoke on, you know what I mean? So it's like, I don't care about a BS cease and desist letter that, first of all, number one, is not, you don't even have the right spelling or punctuation in the damn letter. It was a total BS letter. Like, you're a weirdo. You're such a weirdo. You're such a weirdo. Like, leave me alone. The harassment continues. The harassment continues. Like, leave me alone. That reminds me. I have to do something else considering that. No, I didn't start anything. I'm allowed to say she's scary, and I'm allowed to say whatever I want. She started it because she was talking behind the scenes, running my business to other people. So that's not going to happen. So when I speak up on it, it's a problem. And you're now deflecting. You want to put a cease and wait. So you're trying to silence me? If what I'm saying is not true, why would you want to silence me? And I don't think people know what cease and desist letters are. So when you put a cease and desist, you're trying to make somebody be quiet. Why are you trying to silence me? I'm not trying to silence you. I don't care what you say, because all you're saying is lies. If all I was saying was lies. Okay, that's number one. And when you do write a cease and desist letter, make sure that you get it notarized. You're supposed to get it notarized. You're supposed to send it, and you have to get it signed. Or you have to get it sent to the person, and then they have to open up, like, you know, like an email or like mail or something, and they have to sign it and send it back. I don't know if your lawyer told you this, but that's what has to happen. So putting it on a social media site for the world to see is not how you send a cease and desist. Just want to let you know in case your lawyer or judge, I don't know what the hell, in case your auntie didn't tell you. No, cease and desist letters are for people who are harassing you, people who are ongoing harassment. You need a cease and desist because you are harassing me at this point. You've made like 100 lives. You've put my full name in the lives. You put me in the thumbnails. You are a creep. You need a cease and desist. I have removed the lives, and I honestly don't want anything to do with you because you're like a stain.
So, Ms. Johnson, are you saying that you were mutually talking about one another on the social media platform that is YouTube? It's a yes or no question, Ms. Johnson. But I'm the mother. Ms. Johnson, it is a yes or no question. Were you mutually talking about one another on the social media platform that is YouTube? That's my daughter, Your Honor. Ma'am, I'm not going to tell you again. The next time, I'm going to have you escorted out. But I'm her mother, and that's my Caucasian bailiff. Escort the young lady off the back row. Escort her out. But that's my mother. It's my mom. She's my support. Well, you should have brought an attorney, Miss Johnson. Now, it sounds like you all were mutually discussing one another on YouTube. That's what it sounds like. You removed yours. And then you came and you filed the charges. Is that correct? Yeah, I guess so. Yeah. We were talking, but I wasn't harassing her. I was just talking and going live on the platform. And that's how I make my money, Your Honor. It's entertainment. It's how I make my... Okay, thank you, Ms. Johnson. Thank you.
You're like a stain that you can't get out of your favorite shirt. So I definitely don't... I would never put you on a thumbnail. I would never put your full name in a title. No, that's harassment. So it's fine. I'm just giving you some pointers next time you want to send out a cease and desist. That's not how you send it, sis. Yeah, like I said, what I was saying was not the truth, or here's the thing though, let's talk about defamation for a second. What I said, I never said anything like, I know this to be fact. I said that this is what you had told me. I was reiterating what you came out of your mouth, just like the abuse allegations. I reiterated it. You put it into my ear. I put it out of my mouth. So just like you said, that was a lie and I was lying about that. And you came online and you tried to do damage control. And then it came out. First of all, you can't say that's defamation because you have since then come online and confirmed what I had said a year ago, 2 years ago. So that's fine. Now the next thing I have said is a lie. Okay, cool.
So, to the defense attorney of Ms. Dukes, what say you all on the matter? We know where the issue started. Sounds like Ms. Johnson said something online that triggered Ms. Dukes. Ms. Dukes responded, and they went back and forth. Well, it sounds like Ms. Johnson made an allegation about somebody, Ms. Dukes' ex-spouse and the children. Ms. Johnson, is that true?
I don't care. Like I said, I'm just saying what you had told me. Are you lying? Maybe you lied when you told me that. I don't know.
So you came on the public platform and exposed something that you don't know to be truthful? Is that correct, Ms. Johnson?
But I think that the man involved needs to take that up with you because you said that to me. Maybe you said it out of anger. Maybe, I don't know. I'm just repeating.
So where did the allegations of essay against children come into play, and how did that make it to the social media platform versus to the proper authorities, Ms. Johnson?
What you had told me. Okay? So if it's not true, or if it's defamation, or whatever you're trying to claim it is, take it up with yourself. Because you told me a lot of things about a lot of people, and who knows what's true and who knows what's not true. I don't know. Take it up with yourself. You know? That's none of my business. I'm off this topic. I only came live today because now you're playing CPS games. I didn't call CPS on you the other day. I don't do that to people. I wouldn't do that. No, I don't have time to. I don't have time to do all that. It didn't come from a lawyer. Anyone can go online and make one. It's like saying, please don't talk about me. Okay, that's fine. Anybody can pursue any legal action they want to. Go right ahead. I know that I will be making a police report for the threats. Actually, I'm going to do that right now. Give me a second, because I don't know. You want to continue to play with me, so it's okay. No problem. I need to find.
So, Ms. Johnson, it sounds like when you made the report that you didn't think the threats were actionable, and it doesn't seem like you were in fear of imminent danger. So what was your rationale for filing these reports?
Find out, because sometimes the police will come to your house and you can make a police report, or you go down to the station. I meant to do this yesterday, but I got too busy. So we will do this now. And I don't need to put a cease and desist. I'm asking you to stop speaking on me. Period. Stop speaking on me. You put the address out, which I did screenshot it, which it has like some of my address on it. You purposely showed some of my address. I don't know why you're doing that, but you made sure you blocked out your whole address. It's like the games for me. It's the games. Go down to the police department. Yes, sir. I'm wondering, can I come down there to make a police report, or can the police officers come to my house so I can make a police report? Yeah. Yeah, hold on. I'll take that number. Let me get it. Let me write it down. I think I have a pen in here. Maybe I don't, though. Here, hold on. I'm going to have you. Yeah, he gave me the non-emergency line. Okay, cool. Well, I'll do that when I get home. I do need to get home so the CPS worker can come see the kids. Yeah, I'm not playing these games with you, ma'am. I'm not doing that. You are a complete weirdo, okay? I don't want anything to do with this situation. I told you that from the jump. You spoke on my children first and my custody situation. I don't know who told you that was okay, and who, I don't know why you females even think that that's okay, because it's funny, because everyone's like, oh, kids are off limits. Kids are off limits. Kids are off limits, except for when it comes to my kids. You guys can speak. And I don't speak on kids. I speak on the parents. I speak on the same shit y'all speak on. You know what I mean? I'm not up here dragging a child saying, oh, look, horrible. I don't care. Put it down on your cease and desist letter. I said you're horrible, because you are. You're not a good person. Yeah, she spoke on my mom. A whole bunch of shit. Then I have all that shit recorded. It's so funny. And it's so funny how people have selective memory and selective hearing. I didn't say shit about shit. She said it out of her dumbass mouth, what was happening to her kids. She said it first. I was on live listening to her live when she said it. So when you dumbass bitches report on shit, get your facts straight. She said the shit first. And I still didn't say nothing. And then I woke up to an Instagram post talking about AJ on her Instagram. It was an Instagram story post on her fucking Instagram about my son first. AJ's name was on her fucking Instagram post. So yes, I put my community post up. I sure did. But don't ever fucking say, Olivia started.
Okay, Ms. Johnson. So the information that Ms. Dukes published, was that information true or false? Ms. Johnson, was the information true or was the information false? Okay, it was true. All right. So, Ms. Johnson, are you aware that it's not a crime to discuss true information? There is no statute, law, or any prior case law that will restrict somebody from publicizing true and factual information. Ma'am, did you just say, Alexa, what does factual mean? There is no Alexa. We are in a court of law. Factual means true. Yes, Miss Johnson. Yes, Miss Johnson. Okay, Miss Johnson.
With her, Olivia did this to her. No, the bitch did it to me first. I made this about us. You were running my fucking business. You've been running my fucking business. Before it was to the fat bitch in I'm not gonna call her fat. I'm not gonna say that. The annoying bitch in California. Before you started running my business to her, you were running my business to mods. Remember, stupid? Your mod had come out and your mod was against you. Remember? Because you're so stupid. You run everyone's business to everybody. And they had told on your ass. They exposed your ass. Your own mod. And what did your mod have in the messages? Things about me and my son. Me and my son. So before you come up here and you lie and say, I haven't been talking about, nobody's checking for her. Nobody. Girl, you've been speaking on me behind the scenes. If you had something to say, come up here and say it with your chest like you've been. But I see why you don't do that. You don't do that because when you say it with your chest, girl, you look like a damn fool. You sound like a damn fool too. You can't even say what you really want to say because you don't even know who the fuck you are. So you don't even know who to be. So it's like, you don't know what to do, what to say. You're just up there like rambling and copy and pasting every fucking thing on the internet. Girl, shut the fuck up. Nobody cares. Nobody cares.
Yes, defense attorney, did you have something to say? Well, yes, Your Honor. As you can see, Ms. Johnson went that same day and filed a complaint of harassment and threats. However, she was also engaging in mutual harassment by her definition. They both went back and forth, Your Honor. They both talked about one another, Your Honor. The only difference is my client, Your Honor, only spoke facts. And Ms. Johnson, she made up things to which she had no knowledge or factual basis, Your Honor.
Okay, cool. So the big explosive bomb was Lorenzo is my baby daddy. That's your bomb, bitch? Okay, girl. All right. Well, I'm happy that you think you did something, girl. I'm telling you right now, you didn't do shit. Because you don't know shit. Lord Jesus. You don't know my life. You don't know my baby daddy. You don't know who he is.
Ms. Johnson, so in your prior testimony, and it's a video, you stated that Ms. Dukes was telling the truth, and you subsequently followed up this video saying that that gentleman was indeed your child's father. So what is your premise for harassment?
You know just as much as the motherfuckers on the internet know, which is nothing. I was just talking to my baby daddy right now. And thank God for him, man. Thank God. I swear. It feels so good to just be like, cool. Like, oh my God. Oh, bye. The fuck? Talking about I disrespect my mama. Girl, just lying. Just lying, girl. Talk about my son didn't go with his dad. He went with Miss Stuff. How do you know this? When did I call you up and say, oh, hey, girl, yeah, we weren't even talking. We have not talked, you weirdo. What do you think, that we're talking in your mind or something? Are we having like secret conversations that I don't know about, like in your head? I'm confused because I have not spoken to this girl. I didn't speak to her my whole pregnancy with Kailani. I did not speak to you. I was so sure I called you and I said, oh, I got pregnant, and I blocked him. I trapped the nigga. What? I blocked him. Girl, what? I got pregnant in Florida. I was not talking to you, you dumb weirdo. What you mean? All these fucking lies, girl. You're a fucking weirdo. And I don't care who believes the stuff that comes out of my mouth. Y'all don't have to believe me. Y'all can believe whatever the fuck you want to believe. But if history is correct, last time I came up here and spoke on some shit the bitch told me, the bitch showed me, I was correct, right? Oh, okay. Oh, okay. Okay, cool. Well, that's that on that. That's literally that on motherfucking that. Nothing else needs to be explained or said. I don't give a fuck. I'm so sure. You have a lot of nerve. And then you want to send out a bullshit ass cease and desist when you are the one harassing me. You are the one threatening me on social media. You are the one threatening me, bruh.
Ms. Dukes responded. You didn't like the response, but you all continue to go back and forth. And at no point in time have you expressed a genuine concern for your safety or thinking there was an imminent threat on said safety. All I'm hearing right now is two people going back and forth using a social media platform. Is that correct? Your Honor, I didn't start anything. I didn't say anything. I didn't do anything. Ms. Johnson, is that correct? Is a yes or no question. Ms. Johnson. Ms. Johnson, are you going to answer the question? Defense, do you have anything? Well, Your Honor, as you can see, Ms. Johnson has a terrible habit of being a habitual liar. In that prior deposition, that video that we just witnessed, she lied several times. My client responded to Ms. Johnson on social media platform, to which they both have some semblance of popularity. However, the back and forth was mutual. The only difference is Ms. Johnson came up here and told things that were not factual about my client. All right. Do we have any other evidence? Your Honor, I want to show the court Exhibit J. And this is a testimony from a witness that goes by the name of One Love. And this will show you that Ms. Johnson clearly was not in fear for her life at any point in time, because this is after she filed the charges for the alleged harassment and threats. And this was her response to my client, Ms. Dukes.
So let's get into this.
We about to get into it with your ugly fucking ass, Quasimodo looking ass bitch. Hold on. Give me a minute. Because you just a dirty little slime ball. You know that? And that's why Liv is the way she is. Because you dirty ass slime ball ass chicks are nasty gutter hoes. Hold on though. Because it's about to be a read for the century. $5 Dukes. Broke ass bitch. Can't pay your water bill. You stank asshole taking
Ms. Johnson, is that your likeness and voice where you reference Ms. Dukes and begin to call her names? And this occurred after you filed the charges? So you continue to engage in negative, possibly threatening harassment behavior? So were you ever in fear of any danger? You didn't think that maybe this would provoke the situation further? It doesn't sound like you were in fear at any point in time, Ms. Johnson.
fucking bird baths by the sink. You dusty bitch. Hold on a second. Yeah. Quasimodo. Yes. Y'all remember that movie? That's exactly who the bitch looks like. Quasi motherfucking Modo. They have the same exact nose, the same exact face structure. The bitch looks like Quasimodo. Period. Period. I remembered that. I knew she looked familiar. Hold on. Let me put my baby down. But you know Chris had a little crush on me, which he's a nasty dirtball himself. You guys are both nasty ass dirtballs. But can you imagine if I hit up Chris? She would be sliding down the motherfucking wall. And
Miss Johnson, is that the same Chris that you referred to as allegedly SAing Ms. Duke's children? And you're saying he had a crush on you? And can we imagine if you hit him up? Okay. Well, I feel as if we have a good understanding of this case, and it's been about 40 minutes, give or take. I will hear one last thing from the defense, and then I'm going to make my final judgment.
That's precisely the reason why you need to make sure that all these messages that the prosecutor are relying upon are analyzed thoroughly. Okay. Now, can you go to jail for harassment in Texas? Yeah, technically you can. Under Texas law, the crime of harassment is a Class B misdemeanor, punishable by up to 180 days in jail and up to a $2,000 fine. So I'm not going to go through a lot of the legal defenses here for you, but I do want to identify, number one, if it's electronic messages, your first defense is that the messages were actually First Amendment protected speech under the law. And so if that's what your detective is relying upon in order to try to claim harassment, that's the first area your attorney needs to attack. Now, what's the next area? What about lack of criminal intent? What if the communication was sent to someone that was reasonably annoying or alarming, but there was no criminal intent? In other words, what if the communication took place for some other purpose other than the intent to annoy or alarm? Remember, there must be specific criminal intent that it was sent to annoy or alarm. Now, I'm going to give you an example. We see this very frequently take place between divorced parents communicating over their kids. We've had clients who have sent text messages, like we had a client that we basically had a father that sent a message to the wife or to the mother, and they had been divorced about the kids. And this client sent something over saying, basically, I heard that our son was seriously injured and taken to the hospital. All communications, he continued to message back and forth. The ex-wife basically cut off communications, and for over 8 hours, all communications had stopped. So he was sending multiple messages, calling, doing this repeatedly. Of course, why? What was the intent? His worry was that he was worried that his son was seriously injured and wanted to determine the status of his son medically. His ex-wife, though, think what she did. She wanted to use this as an advantage in divorce court or in family court. She turned around and tried to claim that the frantic messages were a basis for harassment, that he was harassing her. We later learned that the alleged injury to the child never even actually occurred. It was something that was just thrown out there that, of course, kind of baited him into this conduct. So it's important to understand the state of Texas must prove that the messages were sent, the communications took place with the intent to annoy, alarm, or harass another. Okay. Finally, the communication. What if the communication was not actually reasonably annoying or alarming? So the very nature of the question shows that it is an opinionated conclusion, is it not? So what might be annoying or alarming to one person may not be to someone else. And so as a result of that, look, we've actually seen communication that's arguably very benign and lacks aggression, and a reasonable person would differ on whether or not it met that definition under Texas law. So that goes back to, you don't have to prove anything. Prosecutors got to prove everything. Okay. So these are just a few of the examples of some things you might be able to do as far as a legal defense if you or a loved one has been charged.
Can I get any closing arguments? We'll start with Ms. Johnson. I didn't do anything. Like, she harassed me. A black bitch. Excuse me, Your Honor. She harassed me, and I can't believe it. And I didn't say anything. I didn't do anything. I just, Okay, Ms. Johnson. Now back to the defense. Any closing statements? Because at this point, it's time for lunch. Well, Your Honor, let's go back down the timeline. All of this started on or around the beginning of May 2014, where the plaintiff initiated contact with my client via social media, the social media platform of YouTube. My client responded. She made some statements that made Ms. Johnson uncomfortable, but however, were not criminally liable for anything. They were not criminal statements. They were just something that Ms. Johnson didn't care for. And Ms. Johnson responded by putting out false allegations about my client and her children with no proof, no rhyme, no reason. And she admitted that she had no knowledge or evidence of these things happening, Your Honor. Following that, she came online and began cursing at my client the same day that she filed these charges regarding this particular case that we are before you about. Following that, a couple days later, she got back on the YouTube platform and referred to my client by name, calling her out of her name. Your Honor, I ask that you dismiss this case. This is a case of two individuals who do not get along and mutually went back and forth. From the plaintiff. My client lives over 200 miles from the plaintiff and has 5 children in her possession. She has no reason to travel from Austin to Arlington and doesn't have a lot of opportunity as a single mother, and she has a toddler with her full-time. No reliable vehicle to travel over 3 hours to get to the plaintiff. So there was no case of imminent threats. And as you can see by the plaintiff's conduct after filing the charges, she was never in fear of her life, Your Honor. I ask that you dismiss this case and my client be able to go on about her life, continue to raise her kids, and make her content. In the case of Olivia K. Johnson, and the K is definitely for Karen, all charges are dismissed. Ms. Johnson, shame on you for wasting the court's time when you initiated contact with Jasmine Dukes. You continued to carry out contact after your so-called threats were issued. You came up here and further instigated the situation after filing the charges and continue to this day to engage with the defendant. You like it, you love it, all charges are dismissed. Ms. Johnson, never come back in my courtroom.